Hi, this is Ty Hyderali. I'm a plaintiff's lawyer. We concentrate in employment law with offices in New York and New Jersey. I want to talk to you today about a very interesting and somewhat disappointing case that came out of the Second Circuit Court of Appeals. And in this case, there was two individuals. One was George Mandela and the other was Charles Barnett, who in 2017 applied for positions at NTT Data Incorporated. And NTT Data Incorporated is a global IT company. And these individuals applied for employment at NTT and were accepted as employees of the company. So far, everything looks good. Well, NTT then ran a background check on Mr. Mandela and Mr. Barnett, and it appeared that they had fairly extensive criminal background, some felonies in their past. And NTT then applied what they contended was a facially neutral policy of refusing to move forward with these two individuals' applications for employment. And they contended that because they have a criminal background, because they're felonies, they were not going to move forward with their offers of employment, and they withdrew them. Mr. Barnett and Mr. Mandela then filed a lawsuit against NTT contending a violation of a statute called Title VII. And Title VII of the Civil Rights Act is basically a statute that says if you've been subjected to racial discrimination in the workplace, you have a cause of action. And they sued. And they basically said, hey, listen, when you look at this policy, which may appear facially neutral, it's not. There's what's called a disparate impact of racism that's embedded in this policy, because when you look at national statistics, it will reveal that in this country, in the United States, there is a significantly greater number of African Americans who have a criminal record compared to Caucasians. And so, although the policy may be applied in what appears to be a facially neutral, non-discriminatory manner, the impact of the policy is to discriminate against African Americans. And Mr. Barnett also contended that more companies are likely to use criminal convictions against African Americans compared to Caucasian employees. So that was the argument. Unfortunately, what happened was the court said, no, regardless of whether there is a disparate number of African Americans who have a criminal background, that doesn't necessarily represent the pool of applicants applying for jobs at NTT. And the court said because of this potential disconnect, because you can't look at one population to assess another population, unfortunately, Mr. Barnett and Mr. Mandela, your cases are dismissed. Now, you do have certain rights if a company does do a background check. There's the Fair Credit Reporting Act, which the company has to follow with regard to getting consent and giving information if there's adverse information that results from the FCRA background check. And if you're in such a situation, you may want to consult with an employment lawyer. This case, of course, was in New York in the Second Circuit. And it remains to be seen what happens on a national basis with regard to these types of issues, because, of course, many companies do background searches, and many people, unfortunately, have criminal felonies in their past that may come up in a background check. Well, this is Ty Hyderali, unfortunately reporting about a not-so-great case if you're a plaintiff's employment lawyer or plaintiff's lawyer who concentrates on employment law. Be safe and be well.